You're at home, music playing, totally relaxed, when suddenly cops are knocking at your front door. You turn down the volume and you don't answer. But suddenly, cops kick down your front door claiming it was an emergency. Can they really do this without a warrant? I'm Jeff Hampton, the people's lawyer, and in today's video, I'm covering the legal loopholes cops use to invade your home and what you can do to stop them. Number one, what are these so-called emergencies that cops can claim as an excuse to knock down your front door without a warrant? Under the law, they're known as exigent circumstances. But what does that mean exactly? In plain language, it means an urgent, unexpected emergency where police believe they must act immediately, so quickly that they don't have time to get a warrant. Normally, under the Fourth Amendment, search and seizures of anything inside of your home requires a valid warrant signed by a judge. But the Supreme Court has long recognized that, quote, if there's a true emergency, a warrantless search can be objectively reasonable because the needs of law enforcement are so compelling in the moment. But let's be clear, the situation has to be so pressing that the cops pausing to get a warrant would cause serious harm. Harm like endangering life, or letting a suspect escape, or maybe evidence being destroyed. If these conditions truly exist, then the Supreme Court has said that the police department may move forward without a warrant. But they don't just get a blank check here to do whatever they want. It must be analyzed case by case. Now, under federal law, there are some well-established categories that meet the definition of exigent circumstances or an emergency. But you must remember, before they even can use this, cops must still have probable cause that some type of activity, criminal activity, is taking place or has taken place for them to even consider using exigent circumstances as an excuse to enter your home without a warrant. In other words, exigent circumstances do not replace the requirement for cops to have probable cause. In fact, it's an extra requirement on top of probable cause. Think of it this way. Before cops can come busting into your home without a warrant, they must have both probable cause and they must have an emergency so dire that waiting to get a warrant would be completely impractical. If cops don't have both of these things, then entering into your home is unlawful under the Fourth Amendment. As the Supreme Court bluntly put it, they said, and I quote, absent some grave emergency, the Fourth Amendment has interposed a magistrate between the citizen and the police. In other words, if cops are just cooking up some emergency in order to get into your house, it's not going to fly. They need to go get a warrant. So what exactly are these scenarios that are recognized where police can claim an emergency to enter into your home without a warrant? Number one, emergency aid. This is where cops show up at the home and they believe they need to enter into the home to provide emergency aid or prevent a great harm. Think 911 calls, screams for help, or maybe someone's on the ground, lying there unconscious. The whole idea behind this is that cops should not have to wait and go get a warrant if they see somebody in immediate danger or someone's lying on the floor and they need medical help. For example, if cops are at someone's front door and they hear someone inside, or maybe they look through the window and they see someone fighting with another person, and all of a sudden they hear someone crying for help, cops can use this potentially as an example of how they can enter into the home without a warrant under this emergency aid exception. In fact, that's exactly what happened in Brigham City versus Stewart. In that case, officers entered into a home without a warrant because they saw a man inside the home fighting another man, and it looked like the other man was actually getting hurt pretty badly, so they entered into the home without a warrant to render aid. The Supreme Court upheld this warrantless entry into the home because they called it objectively reasonable that the police were entering in, not to enter in and search and look around, but for the express purpose of rendering aid and making sure someone was not in immediate danger. The key issue in Brigham City is that it had to appear to be objectively reasonable to believe that an actual emergency was happening in order for it to be legal. Now, I want to be real clear here. The police can only enter into your home under an emergency aid situation if delaying to enter into the home or ignoring the situation could result in someone being seriously injured or maybe even fatal. However, once the cops enter into the home and they realize that everyone is safe and the emergency is over, it doesn't give the officers a license to now walk around the house, start searching through things, and seeing what else they can use against the homeowner. So number one was emergency aid. Now number two is what's known as the hot pursuit of a fleeing suspect. This scenario is like something out of a movie or a cop show, where you see a suspect trying to avoid the police, right? And he's running through a neighborhood. Maybe he darts in and out of traffic, and then he makes his way to a residence and he enters into the house. Can cops actually now enter that house without a warrant? Generally, yes. If it's a serious pursuit of a fleeing felon, there it could apply. This was first recognized in the case of Warren versus Hayden. The rationale that the Supreme Court came up with in cases like U.S. versus Santana and Lang versus California is that the police are allowed to chase someone who is a dangerous suspect, maybe a fleeing felon, and they are allowed to chase them into a residence for two reasons. If they were just going to stop and wait and go get a warrant, what could happen? Well, number one, the suspect could get away. And then number two, someone else might get hurt in the process of allowing them to be in this home. For example, in United States versus Santana, cops chased a woman who had just done a heroin deal into her own home and arrested her. The Supreme Court called this a hot pursuit and said that someone should not be able to avoid being arrested just by merely running into their home. Traditionally, this applied to felony cases that someone is fleeing from, a felony type offense. However, Santana gave us some very good guidelines here to follow from the Supreme Court that said hot pursuit is, I quote, allowed when police have been in continuous, immediate chase from the crime scene. The crime is a serious or violent one, and the suspect would otherwise escape if not quickly apprehended. However, and this is critical for your rights to know this, not every chase of so-called hot pursuit would qualify for police to be able to enter into a home without a warrant. In Lang versus California, the Supreme Court unanimously ruled that hot pursuit of someone who had committed a crime, in this case a DUI, into their home did not justify police being able to follow that person into their home to attempt to arrest them all over a misdemeanor petty criminal offense. In Lang, the officers followed Lang as he was driving his car for a suspected noise violation and possible DUI. He pulled right into his garage and then walked into his house. And of course, what did the cops do? The cops followed him right in through his garage and attempted to arrest him and completely ignored the fact he was in his home. The court looked at the specific facts and said there was no true emergency going on here. It was a minor misdemeanor offense, and the cops had plenty of time that they could have gone and received a warrant and then entered into Lang's home. So Lang gave us a new rule. If someone is fleeing, it's a hot pursuit situation related to a felony, the Supreme Court is likely going to find it to be justifiable for the police to enter into the home without a warrant. However, if it's a low-level offense, like a noise violation or maybe a DUI, cops can't really rely upon this emergency exigent circumstance exception here because there's no real risk. They have plenty of time to be able to go get a warrant and come back to the house. Emergency number 3, the imminent destruction of evidence. I hear cops say this all the time. We had to enter into the home because we thought evidence was going to be destroyed. This often comes up in drug cases where somebody's inside, the cops claim they hear a noise, and of course whatever noise they hear, they think means somebody's got to be destroying drugs or flushing them down the toilet, so they use it as an excuse to break down someone's door, all in the name of exigent circumstances. Now, the famous case of Cupp versus Murphy helped establish certain factors that the court looks to see whether or not the cops claiming the imminent destruction of evidence can be applied to enter into a home without a warrant. The court will now consider factors such as, number 1, the seriousness of the offense. Are we talking about possession of a joint? Are we talking about manufacturing methamphetamine? Number 2, how strong the probable cause is. And then number 3, how likely the evidence would be gone if they had taken the time to go get a warrant. Now here's a big situation. What if the cops really think they need an emergency as an excuse to enter into your home? What if they decide they create the exigency? What if they create the emergency themselves that allows them to get into your home? This brings us to the very important case of Kentucky versus King. In this case, cops claimed that they smelled marijuana, and then they looked over and they saw a man that they thought had to be associated with that marijuana, so they chased him towards his home in his apartment. They banged on the door, and then they heard movement inside, and they used that as an excuse to break down the door and get into his house. In this case, the court gave us a very specific rule about helping us determine when a cop creates the exigency or the emergency, or when they have the justification to enter into the home. The Supreme Court said, and I quote, "As long as the police do not violate or threaten to violate the Fourth Amendment to create the exigency, then the police can still rely upon this exception." So, if cops come to your front door, simply knocking on the front door, if that means someone then reacts and makes a loud noise or does something that the cops can now objectively interpret as being creating an emergency, then police can then use that as an excuse to break down your door. However, if the police deliberately manufacture an emergency by some illegal means, like maybe they break a window or they do something they're not permitted to do, in order to get you to panic, to use that as an emergency. Now, this is a violation of your Fourth Amendment rights, and they cannot use that as a reason to get into your home. Oh, by the way, the type of offense the cops claim they have probable cause to enter your home for, it very much matters. In the Supreme Court case of Welsh versus Wisconsin, the Supreme Court threw out evidence in a case where the cops just barreled into a man's home with no warrant, all in the name of claiming they needed to get his blood because they didn't have time to go get a warrant and they needed to make sure they had his blood to preserve it in a DUI case. The Supreme Court relied upon that under Wisconsin law at the time, DUI was seen as a very minor offense. And because it was a minor offense, the government's interest here was very minimal because it wasn't considered a serious crime, so there was no real strong emergency that would allow them to enter into the home, and they had plenty of time that they could have gone to get a warrant. In other words, if cops are going to try to kick down your door in order to gain access to so-called evidence they think you're about to destroy, it better be for a very serious crime and not some minor misdemeanor offense, because the court could likely look at this and say that your Fourth Amendment rights of privacy for your home trump whatever the police think they're going to gather or stop from happening on a minor offense. The bottom line, if cops think you're about to destroy evidence, maybe they think there's evidence about to be flushed or maybe something's being destroyed, it better be related to a crime that is a more serious offense, because it's going to be a much weaker claim for the police if it's a trivial misdemeanor offense. When I was in law school, I got into a serious car accident. I was injured, overwhelmed, and at the time, I thought hiring any lawyer would be enough. I didn't realize how much my case was actually worth. And by the time I did, it was too late. Here's the truth. Insurance companies are in the business of paying out as little as possible. They often start with lowball offers, hoping you will accept them before you realize how much your case is worth. If you've been seriously injured, you can check out Morgan & Morgan, America's largest injury law firm. Morgan & Morgan's results speak for themselves. Just recently, Morgan & Morgan helped clients achieve $12 million in Florida, 34 times the highest insurance offer. A $26 million settlement in Philadelphia, 40 times the highest insurance offer. They have experience fighting for injury victims and going after the compensation you deserve if you're their client. Here's what makes them different from everybody else. No upfront costs. You pay nothing unless you win your case. They make it super easy for you to start your case in just a few minutes right from your phone. And most importantly, they have a nationwide team of attorneys ready to take on the big insurance companies. If you're wondering how to get started, it's actually really simple. You can go to their website, answer a few questions, and submit a claim without ever having to leave your home. I wish I had known about Morgan & Morgan after my car accident. Don't be like me and trust the insurance company. If you've been seriously injured in a car accident, workplace injury, or any personal injury, your case may be worth more than you think. And you're only a few clicks away from finding out. You can check out Morgan & Morgan at www.forthepeople.com/HamptonLaw. Or scan the QR code on the screen to learn more. If you've been seriously injured, you owe it to yourself to know your options, and Morgan & Morgan fights to get their clients the compensation they deserve. Finally, emergency number 4 is public safety or now or never scenarios. Now, this is a bit of a catch-all provision here, but let's say some examples like a bomb threat or a terrorism tip, or maybe some sort of active shooter situation going on. Here, it provides another exception that is in the public's interest for safety. One good example of this is a burning building situation, which brings us to the case of Michigan versus Tyler. In Michigan versus Tyler, there was a building that was on fire, and of course there, the police could enter into the building along with the firefighters in order to fight the fire and to make sure everyone was safe, and they didn't have to have a warrant. But the court in Tyler said very clearly that once the fire was put out, in order for the police to continue any type of arson investigation, they were going to have to get a warrant. However, if in the process of putting out the fire, they saw evidence in plain view during the fighting of the fire, that could be taken and used in the investigation. Now, I've talked about this one before, but it's really important that you remember, if a cop ever shows up at your front door claiming this emergency exception here, where he'll claim that he's there to do a welfare check or a community caretaking function and he needs to make sure everyone inside is okay, the Supreme Court case of Canigula versus Strom made a new rule. That rule came out very clearly that community caretaking, stopping by to do a welfare check for cops to see how you're doing in your home is no longer applicable to your home. In other words, the privacy protections you have in your home do not allow welfare checks or community caretaking by police to justify that to break down your door to violate your privacy. The only way that cops can now get into your home in that situation is if you're in an immediate emergency aid situation. You're having a heart attack. Someone's passed out on the floor. It's got to be that type of scenario, not just to make sure you're doing okay. So let's play this out. Let's say cops show up at your front door. They knock on the door. They're very loud about it. And in the process of doing it, they take your overreaction and they use that as an excuse and as an emergency now to kick down your door in order to enter into your home. Is this legal? Now remember, the Supreme Court case of Kentucky versus King laid out the test for us. So if cops come to your front door, which they're allowed to do, and perform a knock and talk, and they do it legally, and then maybe you panic and you overreact, and maybe they hear something where someone yells out, or maybe they hear the flushing of the toilet, maybe they hear somebody what's trying to throw something out that they can objectively believe and testify to that they believe is the destruction of evidence. The cops can use that as an excuse now legally to break down your door. But what if instead the police come and they knock on your door and they say, open up or we're going to knock your door down? That would be illegal because they're not permissible. That is not a permissible thing for them to do under a knock and talk. If you overreacted because of the illegal thing that they did, maybe they broke your window, maybe they threatened to knock down your door under just a basic knock and talk. Anything that happens after that would be impermissible. It would be illegal under the Fourth Amendment because why? They created the emergency. The police manufactured it in the hope that you would overreact so they could get into your house. This leads us to another question I've had other people ask me on my comments on my videos. If cops actually can now use this emergency to get into your house, how long can they actually justify staying in your home? And what else can they search while they're in there? This brings us to the case of Mincy versus Arizona. Now, this was a tragic case because this was an undercover drug bust that went bad. One officer lost his life, and there were multiple people injured inside the home. Now, the initial entry by the police was justified by exigent circumstances because they needed to be able to enter to make sure there was no shooter at large and no one else was at risk. The problem, after the scene was secure, the police then conducted a 4-day exhaustive search of the apartment without a warrant, calling it a murder scene exception. The court ruled that this was an illegal search. Why? Because the emergency had now ended. Once the emergency was over, the need to enter into the home without a warrant ended. So now the cops had to go get a separate search warrant justified by probable cause and signed by a judge in order to be able to come back and conduct any further investigation. Mincy is the go-to case that established the principle that exigent circumstances only last as long as the emergency lasts. Police can't just keep searching on and on under that excuse. The only way they're allowed to get inside the home is to secure the premises under the emergency. And once they realize there is no more emergency, they must not touch or search anything else, and they must come back with a warrant. So if an officer ever makes their way into your house and says, we're searching your place from top to bottom because someone else was hurt here earlier, you'll know right away Mincy says that's an illegal search. So we've just learned all these Supreme Court cases about exigent circumstances. So what is the actual rule that it provides us here? Taking them all together, we learn that probable cause plus a true emergency equals a warrantless entry is permissible. But if either element, probable cause or a true emergency, is missing, it is an illegal search. Oh, and even if the initial entry is allowed under the law, it is only allowable until the emergency is over. No further searching is allowed, and the police must stop any additional investigation as soon as they realize that emergency is over. Okay, so we've learned the law, but what are the actual tips here? What are the things we can take home with us knowing how to stop cops from using an emergency to search our home? After all, understanding the law is one thing, but actually using it to deal with cops in a real-life situation is completely another thing. Now, number one, and this is probably one of the most important tips that you need to know to stop cops, is do not create an emergency by panicking when you see cops at your front door. If cops show up at your front door, don't quickly run to the bathroom. Don't slam a door. Don't yell out to someone. This will immediately give cops all the justification they need to break down your door. Remember, how you respond can make all the difference in the world as to whether cops end up doing this legally. Always stay cool. Don't panic. Tip number 2, always ask for clarification. You can always ask the officer, "Officer, what is the emergency here? Why are you entering my home without a warrant?" Now, it's true. Cops could always look over at you and say, "Shut up and sit down." Or they might actually tell you their reason. Now, if they say something like, "We heard screaming," or "We saw you run inside with a gun," that's important information for you to be able to remember and document. If cops are claiming that they thought someone inside the home needed help, and everyone is standing there from inside the home when they enter into the main door, it's very important that you can look at the police officer and say, "Officer, I know you thought you heard screaming or something, that you thought someone was in trouble inside this home, but there is no need for help. Everyone here is okay, and I do not consent to you being inside my home." Tip number 3, record everything and document the incident. If you can safely pull out your phone and record what's going on, do so. Make sure and document everything. You want to be able to record everything that the police officers are doing so that you can hold them accountable later. Remember, you have a First Amendment right to document and record what the police are doing in their duties, as long as you don't interfere with their duties with that recording. Video is one of the most powerful tools to hold police accountable for their actions. I would not only use my cell phone, anyone else in the home that has their phone, they should record. And if you have a home security system, you should have it running all the time so that all of this can be documented and used to show what really happened. For example, I've actually seen a case where the police report says that the suspect was trying to run away from within the home and tried to get away from the police officers. So the police officers had to give chase, and that led to them being able to go into a particular room and see something. But in reality, that's not what happened. In reality, you actually see the video, the guy's sitting on the couch the whole time, and the cops are just digging through the drawers in the home. That kind of evidence is gold in court, and it may also establish a civil rights claim to show that the police violated your Fourth Amendment rights. And when it comes to the home, there is actually court precedent under French versus Merrill that cops may lose their qualified immunity status, and you may be able to bring an actual civil lawsuit against the police for their illegal activity. Now, what if you can't record? What if you're not in a place that you have access to your phone, or maybe your home security system is not working? In that situation, you could write everything down. Everybody that's in the home, any witnesses that were involved, you need to try to get the names of the officers, get their badge numbers if you can, but more importantly, each witness needs to write down in an affidavit. They can actually outline all the events of what took place because it happened at or near the time of the event, which makes what everyone says to be more reliable in court. Tip number 4, do not consent or sign anything. Here's a little trick I've seen police officers do sometimes. Cops will claim exigent circumstances to enter into someone's home, but then when they get inside, they ask someone to sign a consent to search form. Now think about this for a second. Why would you consent to something when they claim they didn't need your consent or a warrant to get into your house? It's really important. Anytime a police officer is getting you to sign, trying to get you to sign a consent to search form, never sign it. Always refuse consent, because if police attempted to get into your home, but they have a consent to search form that's been signed by you, they could use it to validate what would have normally been an illegal search. If police continue to persist, remember, sometimes it's easy to think, well, the cops are going to come in anyway, no matter what, so I'll just sign the form. Never think this way, because when you do that, you have been tricked into giving up rights that you can assert and stand upon if you end up in court, and you make it much harder for you to hold police officers that are tricking you accountable for their illegal activity. Finally, number 5, never physically resist police officers, but always exercise your rights verbally. This is crucial. Even if the police are overstepping their bounds, unless it's a situation of self-defense, you should do everything you can to resist the temptation to resisting officers physically. Not only will this lead to additional charges against you, but it will escalate the situation, and sometimes it can be very deadly. Keep your hands visible, never make sudden moves, and use your words to object, not your body. Remember, you're never going to convince cops to do what you want them to do by acting physically. But you can stand on your rights verbally and use it to hold them accountable in court later. Always state clearly, and make sure you say it loud enough so it's heard on a recording. You say, I do not consent to search and I do not consent to you entering into my home. If the cops ignore what you say and they barge into your house anyway, if you're able to establish that their claim of exigent circumstances was bogus, it'll make it perfectly clear you did not consent to this behavior and you can hold the cops accountable in court. For me, the rule is to always fight back legally rather than physically. And then when you get into court, you can hold them accountable for what they did. And remember, under French versus Merrill, if cops choose to ignore your Fourth Amendment privacy rights in your own home, there's a good chance you can hold them liable because they no longer receive qualified immunity. We now know how to stop cops from searching our home in the name of an emergency. But what if cops are now just snooping around our home and they decide they're going to cover or disable our porch camera? Check out this next video where I break down if this is legal and what you can do to stop cops from covering your porch camera. See you over there.